Please try to sit on these.
So I believe we have the issue of mic. It was a cable that was loose or burned out or something. So the witnesses can now be mic'd. I understand also the volume has been adjusted for the attorney microphones. And we should have functioning screens. I believe that has been resolved as well. So we will try that as we need. Is there anything we could, I don't know, perhaps, Ms. Beagle, if you could try to put something up on a screen and I'll see.
I think you might have just switched it off.
I switched it off.
It was on.
It was on.
All right, I had table 3 source. And
Yeah,
There we go.
Perfect.
okay, thought you were table 1. Now it went away again. I did not do it.
No, it's still up. That thing at the bottom signals that it's up.
All right, Dr. Burton is in place if you are ready to resume.
All right. Are you ready?
I'm just getting glasses in case it.
Your Honors?
Yes.
While the witness is getting prepared, we were wondering if plaintiffs would be inclined to remove the demonstratives from their opening. We requested it, but they said they would.
The exhibit here on the easel?
Yeah.
All right, we'll ask you to take that down for now then. Thank you.
Thank you, Your Honor.
All right. Dr. Burton, if you want to, do you have your exhibit finder handy?
I do.
Thank you. All right, so Dr. Burton, before the break, we went through a bunch of articles from the, just right after the Civil War, talking about the whipping of African Americans for the purpose of disenfranchising them. And what conclusions sort of do you draw from the articles that we just went through?
Well, it's clear that for the first time, the white Democrats and the former Confederates, those who were doing the whipping, drew the line between criminalization and disfranchising African Americans.
They realized that they could use it as a tool.
That's right.
All right. So against the background of these whippings, did Congress pass a law relating to Reconstruction in March 1867?
Yes.
What did that act? I think that's the first Reconstruction Act.
That's right. It formed because of the black codes, the kind of things like the whipping of African Americans in North Carolina. The South was put under military districts with a commander in each one. I'm sorry, please repeat the question.
I was asking you,
Oh.
what did the first Reconstruction Act require
Right.
North Carolina to do?
Right, okay, and so what it did then was, for the first time ever, African American males, as white males, were given the franchise, and they were to vote for a new constitutional convention. Where African American males would be participating, and that convention had to meet certain requirements by Congress, including would be approved at the 14th Amendment.
And was that in 1868?
It was.
And could you describe some of the delegates who helped lead the 1868 convention?
I mentioned James Hood, the dynamic African-American leader who had an organization before, and then Alvin Tourgier, who most people might remember for his novels, particularly one on North Carolina, A Fool's Errand, but he also was the attorney who argued for African Americans against Plessy v. Ferguson. So many people identified him with the convention. It was actually sometimes referred to as Tourgier's convention as well. There were at least 15 African Americans who were elected as delegates to that convention.
And what were the constitutional provisions relating to voting that were adopted at the 1868 convention?
It was universal manhood suffrage, adult manhood suffrage.
Including African Americans?
Yes, universal, including African Americans.
And did the 1868 Constitution have a provision for felony disenfranchisement?
No,
All right. Was there backlash in North Carolina to the 1868 Constitution?
extraordinary backlash,
And was there backlash to the universal suffrage provision?
especially as quoted in my report, several places about how whites reacted to it. It really turned into a violent campaign. It's often called the Kirk Holden War, so that Governor Holden, the Republican, in fact, had to call in a militia, which was a former Union officer was in charge of to put it down. It was the Ku Klux Klan, which was an extraordinarily terrorist organization at that time. They literally went in and murdered a black constable, town commissioner, and hung him in front so that people could see as a warning. They lured a white Republican down into the basement, stabbed him to death. It was and the campaign, this terrorist campaign that the Ku Klux Klan was so involved in, really made the issue race. That is, if you were white, you were betraying your race if you voted Republican and supported Republican aligned with African Americans. And one of the reasons it did that is because North Carolina, more than any other state of the Confederacy, had more people cross the color line and join with blacks in terms of the Republican Party.
And so growing out of this backlash, what happened in the General Assembly elections in North Carolina in 1870?
The Democrats, after this terrorist campaign, won both houses in the state legislature majority.
And what did they do upon taking control of the General Assembly at this time?
Well, they impeached Governor Holden, the duly elected governor, and they also tried to redo the 1868 convention, to hold a constitutional convention, but the voters rejected that, but they wanted immediately to start changing that.
And did the Democrats retain control of the General Assembly in 1875?
Yes, they had actually gerrymandered too in 1872 and gained control of the judges. They now controlled in Congress 6 of the 7 North Carolina seats through gerrymandering. In fact, creating what became known as the Black Second, where they put all the African American voters in there they could.
And so what did they do in the General Assembly in 1875?
In 1875, they did have their constitutional convention that they wanted to have. In 1870, they now had a large enough majority they didn't have to take it to the people for a referendum. And so they called for a constitutional convention where they amended the 1868 Constitution.
And how would you describe the overarching aim of the 1875 Constitution?
It was to maintain and to keep and to instill white supremacy, and particularly to disenfranchise African American voters.
So at this point in time, did the federal Constitution allow North Carolina to just ban black people from voting outright?
It did, with the particularly, even though I'd say the 13th and 14th Amendment should have, it was intended to, but the 15th Amendment explicitly said that you could not ban people, a group of people from voting.
Okay, so without just banning black people outright as an option, how did the conservative Democrats try to curb black political power in the 1875 convention?
Well, the first thing they did, of course, and one of the things they did is to use what had happened with whipping. And that is to take what had been the law or the statute, which said that only infamous crimes were punished with disfranchisement. They made it, in fact, felonies. All felonies are you're then disfranchised if you're convicted.
And who was the delegate to the convention that proposed the Felony Disenfranchisement Amendment?
Colonel Coleman, as I remember,
And what side did Colonel Coleman fight for during the Civil War?
he fought for the Confederacy.
And what political party did he belong to?
He was a Democrat.
And I refer you to page 28 of your report. Did the county, we also have it highlighted on the
Oh, good.
screen there.
Okay.
Yeah.
Okay.
And so this is Exhibit 27, Dr. Burton's report. So page 28 of Exhibit 27. So did the county that nominated Colonel Coleman to serve the 1875 convention give him any sort of mandate?
Yes, to lead a crusade against the Republican government.
And in per-
Okay, and then there's a quote that the Conservative Democratic Party of Buncombe County, I'm echoing, is that?
A little bit, yeah.
Which, probably, let's see, which had unanimously nominated Coleman and his fellow representative, Thomas L. Klingman, hoped that their delegates would, and I quote, make the radical civil rights office holders party tremble. And he goes on to, call them the mud seals of radicalism, which referred back to even James Henry Hammond in the Senate in '58 and Lincoln's opposition to the idea of mud seals in America.
All right, and we sort of covered this, but just to reiterate, the disenfranchisement amendment that Coleman introduced, how did the class of crimes that the legislature was permitted to disenfranchise differ from prior North Carolina disenfranchisement provisions?
It did not just do a subset, it did all crimes, whereas before it was only the infamous crimes
All right,
or
and
offenses.
was it known at this time that felony disenfranchisement would disproportionately affect African Americans?
Yes, it was widely believed, and I quote some in my report, some examples.
And let's pull up Plaintiff's Exhibit 162. All right. Do you recognize this as an article in the newspaper The Centennial from August 25th, 1876?
Yes.
And if you could just read, starting from now then, while it unfortunately is true.
Now then, while it unfortunately is true that the great majority of the criminals are Negroes, we do not think it becoming in their boasted friends to be telling them of it. And we believe the Negro should vote for the ratification of the amendment because its adoption will tend to restrain their race from crime. If the colored people would elevate themselves on the social and moral scale, they should treat criminals as white men treat them and let them know that socially they have no more place among them.
So is it fair to say that this article is explaining that the felony disenfranchisement provision will disproportionately disenfranchise African Americans?
Yes.
All right. Did Republicans oppose the felony disenfranchisement amendment at the
Yes.
1875 convention?
Yes.
And did that include black delegates?
All the black delegates strongly opposed it.
All right. And I will refer you to page 33 of your report, which again is Exhibit 27. And did the delegates who opposed the amendment express their views as to the racial intent behind the amendment?
Yes.
And you cite an example in your report, if you could just read that for
Yeah,
us.
it's John Smith who argued that, and I quote, "This measure was intended to disfranchise his people and condemn the amendment as villainous, a remark that led him to be ruled down by the chair."
And Smith isn't, all right. And Dr. Burton, Were there other constitutional amendments targeting African Americans that came out of this 1875 convention?
Yes,
Segregation in schools, is that one of them?
yes, laws against intermarriage, taking away, in fact, the court, the selection by the local community of judges. There's a slew of in fact, I believe it's there that they're like, well, go ahead.
Yeah. So let's talk a little bit, so you mentioned school segregation and a ban on interracial marriage. And so let's talk a little bit about the judge stripping amendment. So before the 1875 amendment, were judges selected at the local level or the state level?
They were selected at the local level.
All right, and what happened in the 1875 Constitution with respect to judges?
It was changed so it was selected by the General Assembly, taking
Alright.
away home rule.
And so all of these other amendments that you just described, like the ban on interracial marriage and the segregation, do they reinforce your conclusions regarding the intent behind the Felony Disenfranchisement Amendment?
Yes, they speak to the totality of circumstances, all that's going on to institute what we now think of as Jim Crow and racial segregation, and sort of institutionalized through the laws, white supremacy.
All right, and so did the General Assembly ratify these amendments in 1876?
March 1876, I believe.
And did the General Assembly subsequently act in 1877 to implement the Felony Disenfranchisement Amendment?
They did.
And who chaired the House committee that prepared that implementing legislation?
Another former Confederate, Colonel Henderson.
And what can you tell us about Colonel Henderson's views on race?
Well, we have an editorial that he wrote, or a letter to the editor, plus it was widely known. He supported felony disenfranchisement, was a strong believer, as so many people were at that time, in white supremacy. In 1905, he sort of leads in the lynching of, I believe, 3 African Americans, which were lynched in front of his house, but he's recognized by the newspaper article as the sort of the leader or of that lynch mob, or advocated.
All right. And had he supported the constitutional amendment for felony disenfranchisement?
Yes.
All right. And let's pull up Plaintiff's Exhibit 164. Do you recognize this as an article from the Carolina Watchman from January 6, 1876?
I do.
All right. And so this is a letter to the editor titled "The Proposed Constitutional Amendments" by John Henderson?
Yes.
All right. And can you tell us, what did Mr. Henderson say in the second to last paragraph regarding the Felony Disenfranchisement Amendment?
Can I have a moment to look at the second to last paragraph? I can read it here. Okay. Is that begin, if there is any escape, is that?
No, it's of course none but the most.
I'm not seeing it. I'm sorry about that.
It's one-
Oh, I think I'm on the wrong. No.
164.
Let's see if I can read it from here. Can I stand up to read it? Okay.
Right? I could just read it maybe.
Oops, sorry.
I think you were attacked.
Yes, I apologize. All right. Of course, none but the most, is it resolute? Obstinate, hardened and inveterate felons and thieves ought to object to the denial of the privilege of voting to them, who shall, after the first day of January 1877, be adjudicated, or judged, and guilty of, oh boy, of
I'm sorry, it's hard to read.
felony, and as when in infamous crimes,
It's committed also after that date.
committed also after that date,
Thank you, I'm sorry about that.
which is Exhibit 164.
Yeah.
Why am I not able to- Yeah, I have it now. Sorry, I was, the number didn't, don't know. Would you like me to read it again now that I've got it?
No, that's okay.
I apologize.
I'm sorry, my screen is blurry.
Yeah, mine too up there.
I don't know if there's a way to focus.
Yeah, I think it's the quality of the old documents, unfortunately. But we could just.
The photo looks good, actually. I'm able to read it. I don't know why the numbering was sort of off here on me. I clicked the wrong one.
We'll just move on to the next one. All right, let's pull up Plaintiff's Exhibit 52. And do you recognize this as the 1877 law sponsored by Mr. Henderson titled An Act to Regulate Elections?
I do.
All right, and let's go to section 10, which begins on the bottom of the 4th page of the PDF. I'm sorry, it's a little hard to read there because we're combining 2 pages, but
It's section 10.
section 10, yeah, it's up there on the screen if you can see it.
Yeah, I think I'd rather read it here after my little
Okay.
episode. I'm just trying to find it.
Yeah.
Here's section 13. I just gotta go back. In the exhibit. Well, maybe Yes, I better try to.
It's the page that says 519 in the top right corner,
Okay, this is exhibit 165.
exhibit 52.
52. Okay. And this, what does it say, the page number of it?
It's page 519, and at the bottom there it says section 10.
Yes, okay. The following classes of persons shall not be allowed to register or vote in the state to wit. First, persons under 21 years of age. Second, idiots and lunatics. Third, persons who upon conviction or confession in open court shall have been adjudged guilty of felony or other crime infamous by the laws of the state committed after the first day of January in the year of our Lord, 1877, unless they have been legally restored to the rights of citizenship in the manner prescribed by law.
All right, so what was the scope of the 1877 law? Did it disenfranchise all felons or just a subset?
All felons, not a subset.
All right. And is this the broadest possible disenfranchisement that the General Assembly could have chosen to implement the constitutional provision?
Yes.
All right, and to your knowledge, does North Carolina's felony disenfranchisement statute today continue to disenfranchise people convicted of all felonies, not just a subset?
Yes.
All right. And so you see in this law, it says, unless they shall have been legally restored to the rights of citizenship in the manner prescribed by law. What was the manner prescribed by law at the time for having one's citizenship's rights restored?
This went back to the 1840 law that had been done to try to get rid of individual petitions to the legislature, clogging up the legislature when it related only to whites. And the way you had to do it then was petition a superior court judge.
Okay, so this 1840 law about petitioning was incorporated into this new 1877 law for felony disenfranchisement?
Yes.
And so, because you had to petition, is it fair to say that rights restoration was not automatic upon release from prison?
That is correct.
And did you draw any conclusions about how the requirement of petitioning for restoration before an individual judge would affect African Americans?
Yes, with whites in control, particularly in control of the courts, you would have had a white Democrat who would have been the judge, who would have been unsympathetic to African Americans. There were other things in the law too. That waiting period, a number of things that made it very difficult for African Americans in particular.
And we'll get to the waiting period in a minute. And we talked about how the General Assembly in 1875 stripped counties of the ability to select their own judges. So how did that interact with the felony disenfranchisement scheme in 1877?
That's what I was trying to state before, that you have unsympathetic judges, judges committed to white supremacy, judges who are appointed as Democrats who want to disfranchise African Americans and keep the influence of African Americans from the electorate, or at least dilute and make as small as possible the influence of the African American vote.
And was there also a required waiting period under that 1840 statute for convicted persons to seek to have their rights restored?
Yes, I believe it was 4 years, but then I think you also had to have witnesses who attested for 3 of the years after release from prison that they were of good character and things in court before the Superior Court judge.
So the witness requirement effectively meant waiting at least 3 years after release from prison?
At least 3 years, a little unclear as I studied, but it's at least 3 years.
So that was a choice that Mr. Henderson, Colonel Henderson, and the General Assembly made when they enacted the 1877 scheme to make people wait for some period of time, even if they weren't in prison, to get their voting rights back.
That's correct.
And the 1840 statute they incorporated, with all those hoops to jump through, that had originally been designed, is it right, for people convicted of crimes like treason, really serious crimes?
That's right, the most serious.
And so in 1877, for the first time, they decided that anyone convicted of any felony would have to go through all those hoops and be subject to a waiting period after release?
That's correct.
All right. And let's get plaintiffs 52 back up. And that's this same 1877 Act. And let's turn to section 62. And you don't have to read this, Dr. Burton, I'll just ask you to describe it. All right. So does this provision impose a criminal penalty for voting before your rights are restored?
Yes.
And what's the punishment?
Well, it's an extraordinary for the time, up to $1,000 or imprisonment at hard labor not exceeding 2 years or both.
And is it your understanding that this is the first time North Carolina provided a criminal penalty for voting without having your rights restored?
Yes.
And do you have an understanding of whether it's a crime in North Carolina today, any conviction to vote before their rights are restored?
Yes.
And do you know what the punishment today is for that crime?
Still up to 2 years imprisonment.
All right. Dr. Burton, what are your conclusions regarding the intent behind the 1877 felony disenfranchisement legislative enactment?
I think it's unchallenged, and all historians would agree that it was a way to dilute and to dilute the vote, but particularly to disfranchise African Americans with the understanding that this would affect African Americans more than it did other people at that time. And it was clearly motivated by race, purpose, and intent to do this, and they saw that it would be effective.
All right, let's fast forward 21 years now to 1898. What happened in North Carolina in 1898?
Well, in 1898, you have to back up a little bit. Is that okay?
Absolutely.
To just say that in 1896, once again, North Carolina had more whites join with the Populist Party, a third-party system to the Republicans and African Americans, and in a fusion movement, and they retook the legislature, it was an extraordinary achievement. I said, more than any other state, whites cooperated with blacks and crossed that color line that whites had tried to draw so carefully and legalize.
And so what happened in response to this in 1898?
It really was a terrorist campaign. I'm sure most people here know about Wilmington and the Wilmington race riot. That's just part of a horrific campaign of an overthrow of a legitimately elected interracial government. It can't be described the other way, I think, but a coup d'etat here in North Carolina, in the United States, to get rid of particularly black voters and to threaten any of the whites who were there. And again, they made it about race, that you're a race traitor if you supported or worked with African Americans of the Republican Party.
And did the Democrats then regain the General Assembly in 1898?
They did.
And did they invoke the purported dangers of felons voting as part of their 1898 campaign?
Yes, I believe it's even in their handbook, as I remember, but it was commonly, stated in papers.
So let's pull up Plaintiff's Exhibit 166. And do you recognize this as the Democratic Handbook of 1898 prepared by the State Democratic Executive Committee of North Carolina?
Yes.
All right. If we could turn to page 84, and I think it'll be easier to look at this on the screen just because it's a little, page numbers in this document are a little hard to figure out. Could you read the 5 sentences starting with shortly after the colored man was enfranchised?
I'm going to the exhibit itself, I think a little easier for me here.
Okay.
If that's okay.
Yep.
Okay. Shortly after the colored man was enfranchised, he showed in North Carolina, let me start over again. I read the wrong line here. Get rid of the glasses when I'm reading here and put them on for up there, so it's throwing me off. I apologize. Shortly after the colored man was enfranchised, he showed himself the willing tool of healers and manipulators of the Republican Party. They had not those qualities of easy identification which the white man possesses. They were of a roving disposition, moving from place to place, and could readily conceal their identity. For the same reason, it was easy to import them from other communities and to register ex-convicts and boys under 21 years of age. These facts, which made it easy for them with little danger of detection to register and vote at several different places, were taken advantage of by the unscrupulous Republican white bosses, and repeating and fraudulent registration was so common that it became necessary in order to protect the white voters of the state against having their honest votes offset by illegally and fraudulently registered Negro voters to provide rigid safeguards against this class of frauds.
Thank you. And so is it fair to say that the Democratic Party handbook here is associating felony and felony disenfranchisement with voting by black people?
Yes.
All right. So just generally, what do you take away from that passage about links between efforts to disenfranchise people convicted of felonies in the late 19th century and African American voting power?
Which specifically section is this handbook section?
Yeah, just in general, sort of what do you take away from that passage about the links between felony disenfranchisement and black political power?
It was seen by the white Democrats as a way to disfranchise African American voters and to dilute, of course, the impact of any voters, black voters that might be there and elected, and they were very clear about this. in the literature at the time.
All right, and did the Democrats who had regained the General Assembly in 1898 adopt any other laws targeting black voting
Black voting.
in 1899?
Oh yes, the poll tax and the poll tax, of course, and the literacy laws, and and it's interesting. In a book that came out after I finished my report, they said there were 30 amendments, and the most important, and one of the most important 5 is the felony disenfranchisement as a way to disfranchise. It lists right up with the poll tax and the literacy requirement.
So this is in 1899, they adopted this literacy test and poll tax?
Yes.
Okay. And what was the effect of the literacy test and the poll tax on African American voting?
Well, it pretty much stopped it. I mean, there were efforts here and there, but it pretty much was disfranchising African Americans for that time period. You are entering what we think of as the Jim Crow period is called, but of total segregation, total disfranchisement. When I say total, there are always here or there opportunities or places, but basically made ineffective and made it almost impossible for African Americans to vote in North Carolina during this period.
All right, and you can refer to the timeline demonstrative.
Is it?
Yeah, we can put that up on the
Oh, sorry.
screen.
Okay. I can,
Yeah,
oh, here we go.
and we're just gonna talk very briefly.
Okay.
Okay, well, you have a copy, Dr. Burton.
I do.
And I
just
think all the
found-
judges do as well. All right, so Dr. Burton, in 1900, were any changes made to the felony disenfranchisement statute after the literacy test and poll tax were adopted?
Yes, there were minor changes made to it.
Did those include changes relating to people who had received a pardon from the governor?
Yes.
And what did they do for those people?
They made it, first of all, they changed the length of time, I believe, to 1 year. I haven't looked. I should probably look to see. It's 2 years, I guess, from the date of change. Sorry, but I'm on the wrong thing. Yeah, reduce and eliminating wait period for those, and of course, whose judgment was suspended, and that people also would testify that they had not intended to commit a felony, that there was no intent with the felony.
So reducing waiting period for people with pardons or where judgment was suspended, was this aimed at any particular cases?
Yes, there's a rather, you don't want to say comical when you're dealing with felony, but the case of a mayor in Burlington and the whole city council, they literally, someone had not paid the tax to be buried in the city's cemetery, so they had them disinterred. The family sued them, and the judge convicted them of the felony. So the whole city council and the mayor lost their rights to vote, and this was to address that situation.
They were pardoned by the governor?
They were pardoned by the governor.
They were white?
They were all white.
So the General Assembly made some laws to make it easier for white people who had been convicted of felonies to vote?
That's right.
All right, and fast forwarding to 1933, does the General Assembly reduce the waiting period?
Yes.
And what do they do in 1933?
Well, they reduced it from 4 years, this is after the conviction, to 2 years from the date of discharge.
And what about the requirement to have 5
You
witnesses?
still have to have 5 witnesses, and you also, they have to, say that they have watched and been there and seen the petitioner's characters for the 3 prior years.
All right. And during this period when the General Assembly was slightly relaxing the rules, was reenfranchisement automatic, or did you still have to petition in front of the judge?
You still had to petition in front of a judge.
So how would you say that these amendments in the early 1900s affected African Americans who were disenfranchised as a result of felony convictions?
Well, it really didn't, because you had the poll tax and the literacy laws and all the other mechanisms that were being used at the time, including the last barrier to it was those people who did the registration of voters, even if one could get through the others, barriers that we put up, the major ones being, you know, the literacy laws and then I believe they had a grandfather clause too, as I remember, which would have automatically and had to be done intentionally to exclude African Americans. All that goes to the totality of circumstances to show why the racist motivation of this statute.
And Dr. Burton, in your report, you give an example of how the literacy test in North Carolina was affecting black voting rights as late as 1956. Can you tell us about that?
Yes, and it's in his autobiography, and I've seen it several other places too, but Henry Fry, who goes on to become a beloved state Supreme Court judge, I think the head of it, but he is a Korean War veteran, he is a college graduate, and they fail him on his literacy test when he goes to do it. 1956, Henry Fry.
All
It's
right.
a dramatic example of what they could do in the discretion of these individuals for registration.
All right, so Dr. Burns, skip forward to the 1970s. In your report, you describe the law and order movement in the 60s and early 70s. And could you sort of just tell us what the law and order movement was about in general?
Yes, in the 1960s and 1970, both parties sort of bought into the law and order movement, sort of a national movement. And what it becomes is very clear, and I'll have to take some time to explain that if that's okay, but it really is a way to criminalize African Americans, both in the case of North Carolina for obvious reasons, but in general to win elections, to get people to vote in a certain way. And it really even starts, it's interesting to me, because it really starts when people saw white Southerners opposing Brown v. Board and the sort of violence there against black protesters like at Greensboro and others is sort of, but it got transformed in particular so that it, with the Vietnam War protesters there, of course, and then the war on drugs, that is the idea of drugs and the criminalizing of that. At the national level, we have strong evidence that when John Ehrlichman in an interview admitted that the Nixon administration, I think it's important to understand that Richard Nixon was helped by Strom Thurmond, who sort of sent Harry Dent from South Carolina as a political strategist to do the Southern strategy for the Republican Party, and particularly for Richard Nixon. And of course, Harry Dent is the mentor to, I am blanking on his name after all these years, much more, Lee Atwater, much more famous, but you relate those and you can see how this began to play out. And Ehrlichman explains that he saw as his opponents, in particularly the anti-war protesters and who they sort of saw as hippies doing marijuana, and African Americans. And I want to emphasize, this is not true, but there's a whole literature that sort of trope about, it was middle-class white kids smoking marijuana, but heroin and the dealers were African Americans. And so that's part of this whole mentality that does this. And particularly when Richard Nixon saw and so Ehrlichman says, so we made a decision to go after these people. And also when in '68, George Wallace did so well, combining segregation and law and order and linking them together, Nixon observed that and realized they could use law and order as a way to mobilize people to vote. And as I said, both Democrats and Republicans did this, but in North Carolina it was particularly powerful, I think, at this time. Some of the people involved in the legislation were clearly law and order, even Democrats at that time. And in 1972, George Wallace wins a North Carolina primary. That gives you, I'm doing this because it gives you the context of when these laws in 71 and 73 are brought up. You have for the first time a Republican governor since the Republicans who supported black rights. Mr. Holthauser is elected at that time. And then Jesse Helms, famous for his attitudes on race and law and crime, comes into the Senate from having been a radio personality. So it gives you a context to this. And it is now really a code word. It's really a code word that is, you heard it recently in elections, but the law and order campaign, which is particularly targeting African Americans as criminals. Now, I'll be quiet, but I think one thing needs to be said, and that is this long history of associating blacks with criminality. A recent book by a friend of mine, Kenny Abram, said that it begins when what we would think of as freedom fighters, people who ran away from slavery to freedom, were criminals. That was against the law, so they became criminals. And that begins this long association with criminality. Edward Ayers talks about it during this period, in particular this book on the New South, the trope of black criminality. So I can go on and on, but is that...
That's very helpful.
I do want to say that there's a book that features North Carolina on the suburbanization and this use of the law and order movement to reach the suburbs and white voters, and particularly in the South, to peel them away from what had been traditionally the Democratic Party, and the success of which it was used that way.
All right, and so we're gonna call up an article about the law and order movement in North Carolina. Can we pull up Plaintiff's Exhibit 168?
168?
168. Oh, wait.
Okay.
All right. Do you recognize this as an article from the News and Observer from October 27, 1968?
Yes, it's an article I found doing my research for this case on felony disenfranchisement.
All right, and this is an article sort of about what people in North Carolina think law and order means?
Yes.
All right, and could you read into the record the third paragraph of this article that starts, "To many North Carolinians"?
Yeah, and I have never said this word, so I prefer to, it's not going to be verbatim, but can I use okay. To many North Carolinians, law and order means keep the N-word in their place. Negroes not unexpectedly view the subject from a diametrically opposite position.
All right. So it's fair to say that in North Carolina during this era, the law and order movement was understood as a movement targeted at African Americans.
Yes.
I think you might have touched on this a little bit, but was the war on drugs component of the law and order movement prevalent in North Carolina?
Yes.
And did the war on drugs component of that movement disproportionately affect any race in North Carolina?
Yes, and it was believed to be, particularly the way politicians used it, to mobilize voters to mean African Americans. I said there was a trope. Matthew Laster is the name of the person who wrote the book. I think it's Suburban Revolutions or something like that. But it was used specifically as one of these code words as a way to call out white voters to, again, as they had done, after the '68 convention, after the fusion movement, to look at blacks as criminals.
All right.
Black citizens.
So notwithstanding the law and order movement, were there any federal laws that were passed around this time that tried to make it easier for African Americans to be elected to public office and to vote?
Yes, starting with 57, a fairly weak, but got us our Justice Department set up, particularly though 1964, the Civil Rights Act, in 1965, the Voting Rights Act. And I've written this in my presidential address. I think two things changed the modern American South. One is air conditioning, the other is the Voting Rights Act, and ironically, we know more about how, in fact, air conditioning works than we do about, in fact, the Voting Rights Act and what it is about. And it's become even more evident today. I'll get off my high horse, but yes, 65 Voting Rights Act is critical, particularly critical in understanding what's happening in North Carolina, and part of that backlash. When I'll quickly say the Ku Klux Klan was the most active of anywhere in North Carolina in the 1970s.
Well, so let's turn to page 50 of your report. And again, this is Exhibit 27. Page 50. And you quote from an opinion piece by opponents of the Voting Rights Act in the Asheville Citizen Times in 1959. And what does the Asheville Citizen Times say will happen if voting rights legislation is passed?
This is on page 51?
50.
50, oh, I'm
Yes.
sorry, okay. Sorry about that. Okay. White Democrats in North Carolina also found this reducto ad absurdum argument convincing, since it allowed them to claim that even unconfined idiots and unconfined felons would be allowed to vote if voting rights legislation passed.
All right, and let's turn to the next page, to page 51. And you quote the chairman of the North Carolina Board of Elections making a statement in 1970 warning about amendments to the Voting Rights Act. Is that right?
That's correct, J. Brian Scott.
Can you read what he says?
Yes, if I can find it, yeah, okay. He complained in 1970, note the date, that amendments to the Voting Rights Act abolished all prerequisite for voting as we know them, and warned that while right now, I'm quoting again, right now felons are not allowed to vote, but under the new act, this prerequisite may well be abolished.
And he's the chairman of the North Carolina Board of Elections in 1970?
That's right, and he's the local chairman for Robert Scott's gubernatorial campaign in 1968.
So did you draw any conclusions about whether people in North Carolina in the 1970s are connecting efforts to lift restrictions on felony disenfranchisement with efforts to enable black people to vote?
Yes.
And what conclusion is that? What conclusion did you draw?
Repeat the question before that. I'm really answering that one too, I'm sorry.
Yeah, I was just asking, what conclusions did you draw about the connection that people in North Carolina in this period are drawing between felony disenfranchisement and African American voting?
That, in fact, felony disenfranchisement is one way of keeping African American people from voting. That is, they've known it's been effective before, and that it keeps coming up as you see it by several people of, I think, more moderate even views, worried that felons will be able to vote.
And they're worried that proponents of black voting rights are going to allow felons to vote?
I would have to speculate, but I think this is what they're doing.
Yeah. All right. So after the passage of the Voting Rights Act, were any African Americans elected to the General Assembly in North Carolina?
Yes.
And who was elected first?
Henry Fry, who I spoke about earlier, great admirer of his.
And were voting rights of African Americans a priority for Henry Fry?
Yes,
And
as was the NACP, with whom he was working very closely.
we talked earlier about how he had been forbidden from voting in 1956 for allegedly failing a literacy test. When he got to the General Assembly, did he do anything or try to do anything with respect to literacy tests?
Yes, he got the General Assembly, they put out a referendum to do away with the literacy test in 1970.
And what happened to the referendum?
It was rejected by about a 10% margin, I believe. If I remember, it was rejected by the population, which again tells you something about where North Carolina is at in thinking about voting and voting rights and wanting to hold on to a literacy law that was put into effect to disfranchise black people in the first place, and everyone knew that.
Could you think of any reason other than racism why North Carolinians would have decided to keep the literacy test?
No.
All right, let's pull up Plaintiff's Exhibit 55. Dr. Burton, do you recognize this as a bill introduced in 1971 to amend the Felony Disenfranchisement Statute?
I do.
And it says at the top that the bill was sponsored by Representative Johnson. Who was that?
That would be Joy Johnson from Robeson County, who was described as in several instances as a hell-raising Baptist preacher committed to equality in North Carolina.
Do you recall how many black members of the General Assembly were there in 1971?
There were 2.
And Henry Fry was the other one
That's
besides
correct.
Representative Johnson?
I'm sorry, yes.
Okay. And is it your understanding that they worked together on this bill?
Yes.
All right. And so this again is the original bill introduced by Representative Johnson. And can you read lines 10 to 14? Titled Restoration of Citizenship.
So this is the original bill, and this is
Yes.
exhibit. I want to make sure I got the right one. I missed it. 55, correct?
First page of Exhibit 55,
It
lines.
starts at 10,
Yes.
S1311, Restoration of Citizenship.
Yes.
Okay. Any person convicted of an infamous crime whereby the rights of citizenship are forfeited shall have such rights automatically restored to him upon the full completion of his sentence or upon receiving an unconditional pardon.
All right. And did this proposed bill mention probation or parole or require an individual to complete probation or parole before having their rights restored?
No.
Okay. And did this original proposal require you to go before a judge to get your rights restored?
I mean, can I consult?
Yeah, you see it says shall have rights automatically restored?
Yeah, that's where I wanted to check this. No, did not have to go before a judge.
All right. And was this original version passed?
No.
All right. So let's scroll to the next page of Exhibit 55. Pull that up on the screen. Yeah. Just the.
I'm getting nothing on the screen right now.
Yeah, just one second. Thank you.
Still the same exhibit number?
Same Exhibit 55.
Okay.
Okay, great. So you see this, and you see this says committee substitute across the top?
Yes.
Okay. And can you read us lines 12 to 16, also entitled Restoration of Citizenship?
Restoration of citizenship. Any person convicted of a crime whereby the rights of citizenship are forfeited shall have such rights restored to him upon the full completion of his sentence, including any period of probation or parole or upon receiving an unconditional pardon.
Okay. And so the words probation or parole are added by the committee substitute?
They are.
And this was an amendment from the original version that Representative Johnson had proposed that did not include the words probation or parole.
That's correct. I believe it was Representative Ramsey who was in fact chair of the Judiciary Committee, as I remember and understand it, who made those things. And he was certainly part of the law and order campaign and movement. He actually also ran against in Congress later, Mickey McShaw, and uses pretty close to some code words against him as a fellow Democrat about, wanting grants and sort of what we think of today, hitting toward the welfare that African Americans do. So I think that's relevant as well.
And you talk in your report about some of the law and order bills that Representative Ramsey sponsored?
Yes.
Okay. All right, and I'll direct your attention to line 17, where it says procedure for restoration.
Okay.
And so we just discussed that Representative Johnson's bill said restoration was automatic, and you don't need to read this whole thing, but what does the committee substitute require?
That you still go before a Superior Court judge and have to do an oath while there.
Okay. All right, and then I'm gonna direct you to flip a couple pages further in Exhibit 55 until we get to something titled Amendment.
Yes.
All right, and you see this is an amendment. I'm not sure if the judges have it.
This is a different amendment, it looks like.
This is, yeah, an
I
amendment.
have another amendment. Yes, it's on the back page.
Yeah. All right, and you see this is an amendment, and it's dated July 7th, 1971.
Yes.
All right, and if you could describe for us the conditions that this amendment imposed for restoration of the right to vote by reading starting after upon compliance with one of the following conditions.
A, the Department of Corrections at the time of release recommends restoration of citizenship. B, 2 years have elapsed since release by the Department of Corrections, including probation or parole, during which time the individual has not been convicted of a criminal offense of any state or of the federal government, and C, or upon receiving an unconditional pardon.
Was this amendment adopted?
It was.
And so if a person didn't get a recommendation from the Department of Corrections or a pardon, the 1971 bill, as ultimately passed, imposed a 2-year waiting period for people to get their rights back 2 years after completion of probation and parole.
That's correct.
And so that's pretty similar to the rule from 1933 that we had discussed.
Yes.
All right, with respect to the waiting period anyways.
Yes. Well, yes.
Yeah. All right, let's pull up Plaintiff's Exhibit 56. Do you recognize this as an article from the News and Observer on July 8th, 1971?
Yes, it's an article I found when doing research for this case.
And you see it's entitled Felon Citizenship Bill Gets House Approval?
Yes.
All right. And can you read into the record the paragraph starting at the very bottom of the first column where it says Representative Henry Fry?
Yes. Representative Henry Fry, D, meaning Democrat, Guilford, told the House he favored the bill's original, oh boy, it's small here. I've got this actually quoted in my report. It'd be easier, but automatic restoration of citizens, okay, original provisions, I'm sorry. The bill's original provision, which called for automatic restoration of citizenship when a felon had served his prison term, but he would go along with the amendment if necessary to get the bill passed. Do you need me to read it again a little more coherently or not?
Yeah, sure, go ahead.
All right. Representative Henry Fry, D. Guilford, told the House he favored the bill's original provisions, which called for automatic restoration of citizenship when a felon had served his prison sentence, but he would go along with the amendment if necessary to get the bill passed.
All right. So, based on this statement and your other research, what is your conclusion regarding the intent of the originally proposed 1971 bill, the one proposed by Representative Johnson, with respect to the timing of restoration of rights?
It would be voting rights, citizenship right would be restored when the person was released from prison for serving for the felon.
With no condition about probation or parole?
No.
All right. Why would Fry have gone along with this bill even if that part was stripped out?
Well, that's partly why I went on and could go on another 3 hours about the law and order movement. I think you have to understand what's going on in North Carolina at this time. And so this was the best deal they thought they could get. They were making some procedural changes at least. Less onerous. Doesn't take away that it's still onerous, but they were making improvements in the bill. So as politicians in the making of sausage, there was compromises. And this was a hard one because this is one of the things the NACP that they were working with wanted. But they got the best deal they could get. Remember, there's only 2 black legislators at 1971 time. And you have this huge law and order movement. You have even the KKK at that time sort of, I mean, they actually say this, that they're the real law, that people liberal like Governor Sanford are the people. And so you have this incredible backlash coming out of the Voting Rights Act. Not only that, but it is the case, really, that I should have included in the earlier, in Mecklenburg, that allowed communities to use busing to achieve some sort of equality in school education. And that was a huge backlash that went along with all of these kind of things at the time. And so it's amazing, as I look at it, that they got this far with anything dealing with felony disenfranchisement, which was clearly motivated, everybody knew it from the beginning, to disenfranchise black people, and was still being used as a way, both effectively, that you had the effect of it, disenfranchising African Americans at a much greater level than the disenfranchising white people.
All right. Were any other African Americans elected to the General Assembly in 1972?
Yes, we've spoken earlier about Representative Henry, known as Mickey McShaw.
And let's pull up Plaintiff's Exhibit 156. Do you recognize this as an affidavit of Representative Mishaw?
I do.
And did you review and rely on this affidavit in the course of preparing your report?
I did.
All right. Dr. Burton, if I could direct your attention to paragraph 10 of Senator Mishaw's affidavit.
Okay.
So how many total legislators were in the General Assembly in 1973?
There's only 3,
How many total legislators in total?
170.
Okay. And 3 were African American?
Oh, I'm sorry, I mishear your question.
Yeah.
I'm sorry, okay. Want to do it again?
Sure thing. So how many total legislators were there in the General Assembly in 1973?
There's 170.
Okay, and you previously just mentioned there were 3 African Americans.
That's correct.
All right, so how many of the rest of the 170 were white?
All of them.
Okay. I want to talk a little about how Senator Mishaw describes the racial attitudes of the General Assembly in the early 70s. So could you read the last sentence of paragraph 10 of his affidavit?
The majority of legislators, regardless of party, were conservative rather than progressive when it came to race relations, and the civil rights of African American, and many openly held racist views.
And could you read the last sentence of paragraph 11?
While the Democratic Party, which we belonged to, held the legislative majority at the time, factions within the Democratic Party existed that prevented unity around our civil rights priorities.
All right, and did members of the General Assembly in the 1970s use racial slurs to refer to their African-American colleagues?
Yes, and that's not only in the affidavit, I believe, but certainly there's a YouTube that I cite where several African-American, the legislators, remarked to it, Henry Fry's autobiography. But one of the things that was sort of a backhanded compliment is that these three were referred to as, quote, the Smart Negroes, with, of course, what the implication being that that's rare or something. And that's when they actually said they formed, seems a little strange to say three people are a caucus, but the African American caucus, or the Black caucus, they calls it, with the three of them.
So let's turn to Senator Mashaw's efforts to amend the felony disenfranchisement provision in 1973. Does Senator Mashaw identify an organization that made this a priority?
Yes, the NACP, with which all three of the legislators worked very closely with.
And what does Senator Mashaw say about his fellow legislators' understanding of the racist history of the felony disenfranchisement provision in the 1970s?
You want me just to paraphrase, or you want me to read it?
Either one.
Well, he says that everyone in the legislature knew of the racist origins and why this law was put in, just as the defense counsels agreed with at the time, that all the legislators knew about the racist origins and intent, and the intent was to disfranchise African Americans.
And actually, if you could just go ahead and read paragraph 14 of his affidavit.
Okay. At that time, it was plainly known that the historical and original motivation for adopting felony disfranchisement in the post-Reconstruction era had been to attack and curb the political rights of African Americans. It was also clear that the way the law was operating, in fact, in the state, was mostly aimed at and having an effect on African Americans' political participation and was discriminatory and unequal. This was one of the things the North Carolina NAACP and Kelly Alexander Sr. emphasized, and that we knew to be true. The law was having a major impact on African Americans' registration opportunities and had to be addressed.
All right. So what did Senator Mashaw and Representative Johnson and Fry set out to do in '73?
Well, they wanted to get as much as they could changed to make it less onerous to apply for citizenship. And Senator Mashaw explains other evidence they had learned from '71, all of the contextual history that I've tried to present about what's going on in North Carolina at this time, that they could not get what they really wanted, which was the automatic restoration of rights once someone has served their term in prison. And so they particularly aimed at getting rid of having to do the oath, and perhaps Mr. Mashaw emphasizes that, you know, African Americans not having as much money, perhaps getting a lawyer, things like that, to make this less onerous than it was. Though that did not, as stated over and over again by Mashaw in his deposition and in his affidavit, what they would have liked to have done is gone back to George Johnson's original bill, which restored automatically voting and citizenship right once someone was released from prison.
And were they successful at getting rid of the oath requirement?
They were.
Okay. But where they weren't able to convince their colleagues to make restoration automatic upon release from prison?
No, and as I remember in some place, in one of the things they talk about what it takes to make sausage in a legislature, realize what you have to do, particularly when they had Democrats opposing it as well, I mean, in their own party. And of course, in '72, there had been this big Republican resurgence based upon the law and order campaign.
So if anything, the prospects were less hospitable in '73 than in '71?
It'd be hard for me to say, but I would think so.
All right, can you just read for us maybe the second and third sentences of paragraph 15 of Senator Mishaw's affidavit?
All right, paragraph 15.
Yeah, he's talking about their efforts in 1973.
Okay. Representative Johnson, Representative Fry, and I sponsored the introduction of the bill, House Bill 33, an act to provide for the automatic restoration of citizenship in 1973. I remember we wanted automatic restoration applicable across the board. At the least, the restoration of your citizenship rights after you completed imprisonment. This was a priority for the North Carolina NACP, and it was a priority for us.
And if you could just go ahead and read paragraph 16 as well.
Ultimately, it wasn't perfected. We were able to convince our colleagues to only go so far. Our aim was a total reinstatement of rights, but we had to compromise to reinstate citizenship voting rights only after the completion of a sentence of parole or probation. To achieve even that victory, we vehemently argued and appealed to our colleagues that if you had served your time, you were entitled to your rights. Ultimately, what we achieved was a compromise.
All right, and if you could just flip to paragraph 17 and just read the last sentence of Senator Mishaw's affidavit.
Just the last sentence of paragraph 17.
Yes.
We saw our efforts as a step forward, understanding that it did not solve the original problem. The law was designed to suppress African American voting power, and it had created a perverse incentive to criminalize and charge African Americans differently to achieve that aim.
And if you want to just go ahead and read paragraph 18 as well.
We understood at the time that we would have to swallow the bitter pill of the original motivation of the law. The disfranchisement at its core was racially motivated to try to make the system practiced in North Carolina somewhat less discriminatory and to ease the burdens placed on those who were disenfranchised by the state.
All right. To your knowledge, Dr. Burton, has the felony disenfranchisement provision been substantively modified in any relevant way since 1973?
No.
All right, and I think you were here during Mr. Rodriguez's opening on behalf of the legislative defendants when he noted that the 1970s versions of the bill made it easier to get rights restored and said that suggested that the law didn't have a racist intent. And I think you gave an example in your definition about a poll tax. If the legislature enacts a poll tax for racist reasons and sets it at $100 and they later reduce it to $50, do you think that means that the racist taint is automatically cured?
Absolutely not. It's just reducing the fine does not remove the racist purpose and origins of that bill.
And what about a literacy test? If there's a literacy test enacted in the late 19th century, and then in the 1970s, the legislature amends the literacy test and makes it easier, an easier test, do you think that would eliminate the racist taint of that law?
Of course not. It's still there. It may be easier procedurally, but it still was originated in sort of America's original sin, in fact, in terms of race and racism, and it continues, though in a less extreme form.
And as we discussed, you concluded that the felony disenfranchisement statute, as originally enacted in the 19th century, was intended to discriminate against Black people. Throughout your research into the history and the motivations behind the 71 and 73 amendments, did you see anyone identify any new or independent justification for retaining the rule from the 19th century that felony disenfranchisement continued after release from prison?
No.
Do you have opinions regarding whether and the extent to which the current felony disenfranchisement law carries forward elements of the laws originally enacted by the General Assembly in 1870?
There are at least three. The first is that as the 77 statute did, it disfranchises all felons, not just a subset, but all felons. Two, it makes it a crime if you vote before you have these restoration rights, which I don't need to go into detail, but a lot of people, even earlier among whites, it was confusing when you could go back and vote and things. And then the third thing is they both extend the period after you're released from prison for a period of time.
And did you draw any overall conclusions concerning the extent to which the current felony disenfranchisement statute reflects the same racist goals that you concluded drove the original 19th century enactment?
Yes.
What conclusion did you draw?
That is still there in terms of, as we talked about the poll tax and the literacy law, the original intent has not been done away with. It's been carried over. These are three examples that I gave. Do you want more on that as well? I mean, I can.
No.
Okay.
Okay. Let's turn, we're almost done here. Let's turn to some of the governmental interests that the defendants have asserted in defense of the felony disenfranchisement statutes, disenfranchisement of people who have been released from incarceration. Are you familiar with the concepts of social contract theory and civic republicanism?
Yes.
In your review of the history of the 1870 and 1970s felony disenfranchisement legislation, did you find any evidence that the General Assembly extended disenfranchisement to people who have been released from prison because they believed in abstract notions of social contract theory or civic republicanism?
No.
All right. Other interests that the defendants have at various times advanced in this case include simplifying the administration of the process of restoring voting rights and eliminating discretionary determinations about who gets their rights restored, and deterrence or encouraging people to comply with court orders, or encouraging rehabilitation. In your review of the history of the enactment of the 1870s and 1970s felony disenfranchisement legislation, did you find any evidence that the General Assembly extended disenfranchisement to people who have been released from prison to advance any of those interests?
No.
All right, thank you, Dr. Burton.
All right, we'll take our recess a few minutes early. We're at a good stopping point, so we will take 15 minutes. We'll be in recess until 10 after 3. Thank you.
Superior Court's in recess 15 minutes. Don, hook me up.
Thank you so much.
Yeah, welcome.
Appreciate your help. Yes, sir. Embarrassed about walking off with it. I once was director for